Hello and welcome to the DFW Divorce Insider Podcast, answering all of the questions you didn't know you had about family law. I'm your host, Matthew Eitzen, and for our fourth episode, we are going to be discussing summer possession. Our guest for today is one of the partners here at Duffee and Eitzen, George Shake. How are you doing today, George?
Matthew, I'm doing fine. So good to be with you today.
So good to have you here. Like I just said, we are talking about summer possession, that is, possession schedules and etiquette of possession and rules of possession and so on for children during the summer. Yes?
Yes, sir. That's what we're here to talk about today.
Wonderful. And is that a fairly accurate definition of what we mean? What you mean when you say summer possession?
Yeah, in the simplest sense, when we use that term, loosely referring to a schedule of when a child is going to be with each of that child's parents according to a court order, probably a divorce. Now, there's far more detailed information that comes with that concept, including alternative possession schedules, but in the most simple, clear sense, that is what we're discussing.
Great. So, you mentioned alternative possession schedules, which implies the existence of a standard possession schedule. Am I correct there? And could you tell us a little bit about what a standard summer possession schedule looks like?
Yes, that's exactly correct. We have in our law something called a standard possession schedule. And that law exists in the state of Texas in our Texas Family Code. And we could talk more about the origin of our code and what it means, but this really is a very detailed, set out schedule. And I'll come back to alternative schedules in a minute and tell you a little bit more about this standard summer possession schedule. The first part to understand is that we're typically talking about a 30-day period where the children are with their non-primary parent. And then the second aspect that we're addressing is that the primary parent, that other parent, can select one weekend during those 30 days that the other parent has possession and see the children for one weekend. Sometimes we call that a donut. And the purpose of that is that we have a public policy that states children should spend as much time as possible with both parents. We do not find it helpful for children to spend extended periods of time with no contact with either parent. So we have that small weekend coming out of the 30 days. And then later on that, if you've been doing math along with me, you'll know that most children have a summer that's longer than 30 days. The rest of the summer is typically made up of carrying over the traditional weekend possession that occurs during the school year through the summer, except for these special events such as this 30 days. Now, there are more technical aspects to the summer that we could discuss, but when we refer to a standard possession schedule, we're talking about that 30-day period, that one weekend pullout or fun donut, and then the rest of the summer basically consists of the normal weekend possession schedule, which is the non-primary parent has possession of the children the first, third, and fifth weekends of each month, and the other parent will have possession of the children throughout the rest of the time during the summer.
Got it. Now, you mentioned that part of the reason for this is that sort of part of the foundational philosophy behind the Texas Family Code is that children are best served by getting maximum amount of time with both parents, and they should never be deprived of contact with one or the other. Speaking to that, what could you talk a little bit about both the alternative schedules and then sort of pros and cons of standard versus alternative, and sort of what might attract someone to an alternative possession schedule?
Yeah, great questions. When we meet with our clients at Duffee and Eitzen, we spend a lot of time discussing what a standard possession looks like, what alternative possession looks like, and why certain families benefit from one or the other, and how courts view them. And so if we look at a year of 365 days, and we have this public policy where children are believed to benefit from maximum time with each parent, oftentimes people's minds go to, well, if we don't prefer one parent or the other, that sounds like something like a 50-50 split. And no one objects to that theoretically. It's in practice where we have to consider the needs of the children. So if you have a school-age child in particular, if you imagined a scheduled child slept in a different home every other night throughout the entire school year, we would have achieved that public policy in theory of maximum time with each parent. But what the family courts and our mental health professionals have learned is that the number of times that a child switches homes, the number of transitions in a week's period can really have a negative effect on a child. Not because of the time with the parent, but because of being a young child and living two different places on that frequent of a schedule. And so our legislatures over time throughout the entire country, with a lot of help from mental health professionals, have determined there is some stability in a child spending the night in one home for most school nights, and then seeing the other parent as often as possible around that schedule. And so it's from that essentially calculation of time, we look at a calendar, years long calendar, and see if we follow that standard, the children are spending far more time with one parent than the other. And so, yes, we could make it up with weekends, and we could split holidays and spring breaks in a way to really even out the time that the children parents as much as possible. But really, it's the buildup effect of those 9 school months, 8 or 9 school months is so high. It takes the summer to essentially equalize the amount of time that the children are spending with both parents. Now, many parents look at this standard possession schedule and compare it to their previous life as a family, where they each saw every child every day, and decide, we don't think this standard possession is best for our children. And if you have two parents that are working together for the betterment of the children, at Duffee and Eitzen, we're there to tailor that schedule for whatever it needs to be. It turns out there are some common alternatives. One common alternative would be 1 week with the parent and 1 week the other parent, and it rotates throughout the entire year. And so, because we're talking about summer possession today, I'll take that concept to the summer and say, throughout the summer, many families, many modern families where you have caring, enlightened parents that are focused on the children's well-being, will continue the schedule throughout the summer where they alternate the possession of the children every other week. And then we build on to that. For example, the standard possession code protects Mother's and Father's Day. And we like to ask parents to continue to honor that regardless of the rotating week. It seems like we're all in agreement that the children benefit from being with Father during Father's Day weekend and Mother's during Mother's Day weekend. And there's other aspects we can change through the summer. For example, many families take vacations, and it might be for more than a week. And so we work with our clients to determine if there are family traditions or regular vacations, or just the inclination from our client and the other parent to take longer vacations each summer. And this way, perhaps we can standardize the summer with every other weekend, but then identify how each parent can take swap a week with each other, so each have at least 1 2 week period for vacations and family get-together, things of that nature. Now, there are other ways to create a summer possession, and for me, the most family-friendly, child-centered part of this standard possession order, that it begins with the presumption that the parents can agree to any schedule they wish. So you can imagine children that are in high school that have sports events or travel for sports, or children with special needs or medical needs. There's a lot of variability that comes with our lives and our children that aren't always best met by a standard schedule. And so the Texas Family Code and most divorce decrees and orders that we enter in front of a judge include the introductory statement that the parents can agree to whatever possession schedule they agree to. Then everything we've been addressing today is supposed to be considered the backup plan. If these two parents agree on a very unique schedule that we couldn't even put into any type of pattern, if they agree to it, then the court and the lawyers at Duffee Eitzen believe then that is what's for that family. But we also make sure our clients have a backup plan so that in the unfortunate case where divorced parents can't agree on a summer possession schedule, they already have the backup plan that's standard possession schedule or something else perhaps they've agreed to as the backup plan.
I think we've covered most of the ground when it comes to possession schedules, but are there any sort of strange, anomalous cases or anything we didn't cover when it comes to the different kinds of schedules before we move on to summer possession in practice?
You know, when we talk about possession schedules, we really try to focus with our clients on what is standard, what works for most families, what seems to be a good match for their general needs. But there are some very unique answers to the question of how often do parents get to see children. I'll give you the most unusual example I'm aware of. There's a concept in possession schedules referred to as nesting. And if we were to build a possession schedule that only on a child's comfort and a child's development, this kind of nesting is the answer, I believe. And what it means is the children have a single residence and they spend all of the time at that residence. And it is the parents who go back and forth during possession periods. So it's essentially the opposite of what we all consider with a standard possession schedule. And so in let's say that a unique possession schedule where we have week off, the parents trade weeks. For the first week, the children are in their residence and the father's with them for that week. And the father's the only parent that's staying at the home, the mother's staying somewhere else. And then at the end of the week, the parents swap. The father leaves the children's home, essentially the family residence, and the mother comes there for the week. Now, obviously, this produces a lot of intriguing questions, concepts, and I'll address just a few of the basics here. First, some families have essentially two residences, one for the children and one for the adults, and these two adults switch where they stay in these two residences. So you have perhaps a divorced couple who maintain two shared residences but are never there at the same time. And so you have the same number of residences. The children have one room of clothing, one home schedule, and it's the adults that are completely rearrange their lives. Now, this can become very difficult if parents have children from other relationships or marriages. Parents get to remarried, but for the period of time during a divorce and at the beginning of their new life living separately, this is a unique strategy that incredibly generous parents have done successfully.
Wow, that is very intriguing. I've never heard of anything like that before, but I'm sure that I will be looking it up later because that sounds very interesting. Okay, so schedules, of course, are all well and good, but all schedules eventually have to be put into practice. So we thought it would be a good idea to talk about some of the common pitfalls or mistakes that people make when it comes to summer possession, or sort of the some common problems that you often run into.
Well, unfortunately, when families break apart and divorce, there are usually some strains between the parents, and that can result in some misunderstandings, miscommunications, and occasionally even some misconduct. As attorney at Duffee and Eitzen, my goal when I meet with a client is to anticipate as much as I can and to put in some protective language in an order to get everyone to agree to it to avoid as many of these as possible. However, the common pitfalls occur pretty frequently, and it takes a few years for sometimes a family to get used to these challenges. One example that comes in right away is that during a school year, the non-primary parent will often have a mid-week possession period. So the common one would be Thursday, and it's either for a dinner period for 6 p.m. to 8 p.m., or perhaps even overnight every single Thursday. This is a very common part of a standard possession schedule. That portion of the standard possession schedule does not carry over through the summer. And parties rarely think of that intuitively. And if that concept is overlooked in preparing the parents for this order and preparing for their new life and their new schedule, one or more of the parties may be contemplating that Thursday evening continuing. And the order does not typically include that. Now, the parties, of course, can agree to it on their own later, but that's not a guarantee under the order. And that is a very common concern. Another common issue involves how the dates of possession occur during a summer. So earlier in our conversation, we talked about the non-primary parent getting a 30-day period of possession in the summer. But how that 30-day period is identified is wrought with some challenges. For example, our standard possession orders require the non-primary parent to give notice to the other parent of the days that are being selected well in advance by date certain. If the non-primary parent fails to do so, our order includes a default set of dates. So the court and attorneys previously have agreed upon those set dates based on the family law code. And so, perhaps an individual didn't mean to fail to designate their period of time in the summer, and perhaps they don't like the default date, and it's real terrible inconvenience for other reasons, maybe something with their employer or other family member. And unless these parties can agree, that's the court order. And so we as a group, strangers essentially have chosen what dates that non-primary parent will have with their child. And so this is something we really caution everyone about, to put these deadlines on their calendar as a recurring thing every year, and give yourself a 1 week reminder. And, this is something that has to be looked at well in advance. And there are good reasons for this. You have two households that are trying to plan vacations. You have two households perhaps that are planning summer camps and sports and activities and visits to families. And so this is not something that can be done at the last minute. Organizing a child's summer schedule is very complicated, and our legislatures and our courts have recognized that and require that notice be given in a timely fashion. And then in turn, the primary parent must give proper notice by date certain about that one weekend out that they're going to get during the non-primary parent's third-day possession, and all for the same reasons. We want to be able to give both parents plenty of time to schedule everything they need to. And that's a common pitfall. People miss those dates and misunderstand what they are and misunderstand what their remedy is if they fail to do properly. And I would say a common challenge is the start and stop times of these various days of possession during the summer. And the reason why it's a challenge is because during the school year, so often we use the beginning school day or the end of a school day as an easy time to exchange children. It really allows parents to send children back and forth to the school and kind of interact with each other minimally as divorced parents if they don't want to or don't have to. During the summer months, we don't have that exchange at the school occurring, and we don't have that natural beginning and end of a school day. And so parents live most of their school year based on one schedule time, and then during the summer months, the time changes to typically a 6 p.m. exchange time at each one of these switches of possession. And that may work fine for everyone, or it may be a terrible inconvenience for a family for whatever reason. And if they don't plan for that, it becomes pretty shocking. And occasionally we do get phone calls from previous clients or new clients that are concerned about this change schedule that they just didn't pay attention to or didn't recall. And so that could be a real challenge when you're trying to work out your family's calendar.
So, obviously, we're recording this in April, which means summer is coming up. And in addition to the normal challenges of summer possession, this summer, people are also going to have to confront challenges related to the coronavirus outbreak. So, could you talk a little bit about some of the questions and concerns you've been receiving from clients, problems that have already started to arise related to all of this, sort of what you need to know about summer possession and coronavirus?
Well, Matthew, this is a timely question. Although the standard possession schedule is important to all of our clients, now more than ever, they're concerned about the health of their children, the health of their other family members and themselves. And we've gotten very clear guidance from our courts on several matters. And so the most pressing question we receive is, now that many school districts throughout the country, certainly throughout Texas, are closed, how does that affect possession schedule? The answer we're getting back could not be more clear. The courts have issued guidance that families are to treat our current times as normally scheduled days, so that now that we're in school days time where the children would normally go to school, our guidance is we are to treat every day as if we're on a normal school schedule. And so that guidance is very clear and helpful. Over the summer, there is no change that will occur to the possession schedule based on our current crisis. And by that, I mean no automatic change. Therefore, for our listeners, if they have a summer possession schedule that's in place, that summer possession schedule goes forward unchanged unless there is a court order specific to their case. Now, that leads me to my next concern, which is we have clients that are concerned about a specific health issue. For example, perhaps there is a person in one of the households that are suspected of being positive for coronavirus. Given the spread of this condition, that's certainly a possibility. At that time, that there is a reasonable belief that someone may have been exposed to it, then we're moving forward and determining if we need court intervention to temporarily modify the children's possession schedule to keep everybody healthy. And that's, of course, that's only if the parties can't agree on a temporary change in schedule. Two parents are perfectly within their right to have a discussion about everyone's health and determine if one of those parents lives with at-risk elderly parents and believes it's a risk for children to go back and forth and are going to forego in-person possession with their children for a period of time. And the parties may agree that there'll be makeup time for this time, or part of it will have some makeup time. They could also agree on regular video conferencing with that parent and the grandparents to keep that close tie. Parents all over across the country are doing this today, making good decisions, making sure children are cared for, being educated at home, and everybody's health and safety is being cared for. But under the circumstances where we need to support a family if there's a disagreement, we are ready to go to the judge and outline the concern and ask for court guidance to see if we can have a temporary change in possession so that everyone does maintain a safe home and safe, healthy children. Now, I will add there are a number of people that are very concerned that the other family, the other home, perhaps is not following state or county guidance, or perhaps not making good choices for the health of the children. Unfortunately, divorced families can be somewhat suspicious of each other and perhaps feel that the other parent is not exercising good judgment. And our advice to all of our clients is certainly, if you have a strong reason to believe that, please let us know what it is and we can address it and help our clients address it. But the court is going to require some level of evidence if a parent is making poor decisions and we're asking a judge to change a possession schedule based on folks' conduct. We're going to have some evidence of pretty strong poor judgment before a judge would even contemplate that. And Matthew, I'd like to add, courts all over the state are quite overwhelmed with attempting to conduct business electronically and virtually, and they are hesitant to get involved in what a court might perceive as a petty dispute over hand washing schedules in different homes. And so we want to reserve those resources for when there's a true health concern, and we are happy to represent our clients in those situations and keep those children safe.
There we go. Another specific question I know we have been getting here at Duffee and Eitzen is, what if someone's normal possession schedule requires the children rather to travel by air, such as going to a different state, as obviously airports and air travel are particularly high-risk activities right now due to the airborne nature of the virus. Can you speak to those concerns and have the courts issued any guidance on that?
Certainly. Matthew, when we look at certain families that live apart and require air travel for the children, that comes with a host of concerns without an pandemic being present. So now we're looking at families that have summer possession schedules that require children to travel by air. And unfortunately, we have certain government agencies by county and state that vary drastically. So if we represent a family who has a concern about air travel with their children, we're going to need to investigate each government agency that has any type of authority over that family, because we do not want a family to run afoul of county or state orders for the state of Texas, or county or state orders for the state that the child's traveling back and forth to. Now, repeating myself, I will say, if you have two parents who are capable of making good decisions for the health and safety of their children, they probably don't need our intervention. They could forego the plane travel. They could have the adult travel instead of the children. We can put off the travel until later in the summer. There's a lot of good decisions folks could make to avoid giving the children any opportunity to risk. But if that's not possible, and unfortunately that does come up where the courts need to intervene, we represent our clients and we lay out the two counties, states that are relevant for each home, and what the orders are in place and what exceptions have been outlined. For example, in the state of Texas, it is a provision of the order, the stay-at-home order that's currently in place in Dallas County, that travel to exchange possession of children is considered an essential activity. And so although we're all being terribly careful and protecting our children, the public policy that children are spend as much time with each parent and to honor the court order that says what the possession schedule is, that is considered an essential activity. And of course, all of the precautions can be followed in the exchanges, but that is limited to that locality. And so when we have to contemplate the possibility of, say, children traveling back and forth between Louisiana and New York City, I think there would be grave safety concerns, and that one parent may require the assistance of an attorney in the jurisdiction that the court has issued the order from, and determine what is possible for the possession of the children, the scheduled possession of the children. If it's not possible to keep the children safe during travel, I think the courts are going to be very open to hearing temporarily modifying that possession schedule for the benefit of the children.
There we are. Any last thoughts about summer possession and coronavirus?
Certainly. Regarding summer possession, the goal is for the children to use that time to ensure they have as much contact as possible with a non-primary parent for the vast majority of our families that operate under a standard possession order. And as we've been all experiencing, virtual meetings have become a new norm in our lives. And so if your child is a school-age child, they very likely have been engaging in virtual meetings themselves with their teachers and classmates, perhaps mental health professional. And so, this is a tool that children have become accustomed to very quickly. And so it would be a missed opportunity for a family not to capitalize on this tool for children staying in close contact with both parents and extended family members. As you know, Matthew, many children live with blended families, mixed families, multi-generational families, and additional siblings from other marriages and relationships. And a child's mental health requires a certain amount of predictability and stability. And so, yes, it is different for a child to be dining in front of a computer while visiting with a family in another home. That is part of a schedule that that child's used to. And so I'm encouraging our families to use these tools to the maximum extent possible, because if we have to be in front of a judge soon to talk about the new schedule, I want the child to be a child who's seen both parents as much as possible. And, you know, a Duffee and Eitzen client who is in front of the judge, who's been working hard to ensure the child staying connected to everyone, is one that the court's going to look on favorably. So during these very trying times of coronavirus, while we're keeping our children physically healthy and safe, it's also important that we tend to their emotional and social needs and use all of our communication tools available to us to keep children connected to their parents and their families.
All right, there we go. Well, we're almost out of time here, but speaking of keeping our mental health up, we've been asking all of our guests how they have been keeping up their mental health in quarantine. So if you don't mind sharing, would you just let us know what activities and sorts of things you've been doing to keep off cabin fever?
Certainly. I have a few go-to activities that have become my new life during this time. And the first, like many of our Duffee and Eitzen clients, I have become a full-time homeschool teacher to two children in my home. And so,
Oh.
although that can be challenging for many of us, I and many parents I speak to have a renewed joy for our children's learning, to be able to communicate with the teachers on video conferencing software and to collaborate with other parents and students and teachers on the assignments has become a near full-time job. And it's very exciting and challenging, and it takes up a lot of time for all of us parents who are maintaining our day job, and now our new work our new work is our night job, and we're taking care of children, and it's very exciting. And I'll add, like many physicians and counselors are recommending some physical exercise, great benefits, and I just happen to prefer hopping on my bicycle and riding for about 20 or 30 minutes as often as I can. And it seems to do a world of good for my state of mind and my health, and I really enjoy it.
Well, there we go. I think that's an excellent note to end on. Well, that's it for us here at the DFW Divorce Insider Podcast. George, thank you so much for coming on.
Thank you, Matthew. Thank you to all our listeners.
Yes, thank you to all of our listeners for listening. If you enjoyed this episode, please remember to subscribe to our podcast so that you'll get every episode right when it comes out. If you are looking for family law representation in the DFW area, or if you just want to learn more about today's topic, please look us up at www.duffeeandeitzen.com or at dallastxlegal.com, or just type Duffee and Eitzen into Google. That's spelled DUFFEEANDEITZEN. You can also send us an email at info@d-elaw.com or give us a call at 214-416-9010. Thank you so much for listening. Until next time, I've been Matthew Eitzen, and this has been the DFW Divorce Insider Podcast. Y'all take care now.